Good afternoon, everybody, and thank you for coming along to what is the first in our social housing webinar series for 2023. Our webinar this afternoon is on leasing affordable housing from the private sector, what RSL providers should know. For those of you that don't know me, my name is Fiona McLeod. I am a legal director and solicitor advocate that sits within our social housing team. I'm not doing any of the speaking today. I'm simply here to welcome you all, and I will come back on at the end for the Q&A session. Our speakers this afternoon are Jenna Monteith. Jenna is a senior associate within our real estate team with significant experience in supporting social housing providers in relation to affordable housing. And joining Jenna this afternoon is Claire Mills, who's a senior associate in our construction team that has particular experience in this sector as well. So I'm going to pass over to Jenna. I'll turn my camera off and we'll come back and see you at the Q&A session.
Thanks very much, Fiona. So as Fiona said, I'm going to talk a bit today about leasehold arrangements as between affordable housing providers, particularly registered social landlords, RSLs, and private investor landlords. And the wider context for this is around Scottish Government housing policy. Housing to 2040 was the first long-term national housing strategy paper that was published in March 2021, and that basically set out a route map aimed at ensuring that everyone in Scotland will have a safe, high-quality home that is affordable to them and meets their needs in the place that they want to be in by 2040. The current commitment in that context is for the delivery of 110,000 affordable homes by 2032, at least 70% of those to be for social rent and 10% of them to be in remote, rural and island communities. That policy was reconfirmed recently by Paul McLennan, or just last month, shortly following his appointment. So it's very much still the major policy that's in play at the moment. Most affordable housing is delivered currently through Scottish Government's Affordable Housing Supply Programme, and that's supported by a significant subsidy or grant, financial grant that's available to support RSLs and local authority providers of social rent and mid-market rent to deliver housing. Social rented housing receives the highest level of financial support in line with benchmarks, and the benchmarks are set with reference to location and size, as in bed space. There are higher benchmarks for social rented housing than mid-market rented housing, but there are some additional grants that are available for housing that meets additional criteria, particularly around environmental or low carbon standards. Social housing can only be operated by providers regulated by the Scottish Housing Regulator, and that includes registered social landlords and local authorities. And only not-for-profit entities can be regulated providers in Scotland, which is quite different from the position in England, where there can be for-profit providers of social housing. It's been widely reported, and I think everybody knows that the landscape at the moment is very challenging for the delivery of affordable housing and also housing generally. So by that I mean housing for sale. There's obviously a lot of cost pressures, cost of materials and inflation that are making it difficult for housing developments to come forward, among other issues around availability of workforce. And delays in planning systems potentially in areas. But notwithstanding that, there is the target to deliver 110,000 units by 2032. And so that's why it looks like now is a good time to think about alternative methods or alternative models for the delivery of additional affordable housing, including social rented housing, kind of over and above the traditional or current affordable housing supply programme. And one of those alternative models is delivery by way of a leasehold arrangement as between a private sector landlord and an affordable housing provider. So what that is essentially the scenario where the private sector investor will purchase a completed development of new build housing, and immediately on that purchase would enter into a lease of that housing with an affordable housing provider, either an RSL or another affordable housing provider. And that affordable housing provider would operate the housing as part of its own stock, and be entirely responsible to the private sector landlord for the management and maintenance of that housing. The kind of key difference between this model and a normal purchase arrangement, whether that's purchase of land and then the entering into a design and build contract and paying a contractor for that development, it is really that there is no upfront price payable to the landlord. Usually the consideration payable to the landlord, rather than being the upfront price, it is the rental payment, which will be paid over the term of the lease. Excuse me. So in terms of the lease, just in general, that would usually be what's called an FRI lease, which is a full repairing and insuring lease. And that essentially means that the landlord is displacing almost all of its obligations as owner of that property onto the tenant, in this case, the affordable housing provider. And the affordable housing provider is responsible for all of those obligations and also responsible for the cost of maintaining insurance. And usually that would work in such a way that the landlord would insure, but the tenant would pay over the insurance premiums due by the landlord to the insurer. The tenant will lease the individual units comprising the property to occupiers, either in terms of SSTs, where the landlord or where the tenant, in terms of the lease, is an RSL or a local authority, or a PRT, where the landlord is another entity, as in not an RSL or a local authority. And I will say there's quite a lot of different tenants here, so I will tend to refer to, when I refer to the tenant, what I mean is the affordable housing landlord tenant in terms of the lease with the investor landlord, compared with occupiers who will be the tenants in terms of PRTs or SSTs, depending on the tenure. I should have said that up front. So the tenant will collect the rental income received from occupiers in terms of the PRT or the SST or the SSST, if that's the case, and the tenant will, from those rents collected, pay to the landlord rental consideration that's due in terms of the head lease, and that rent will usually be index linked initially on day one to a published measure of affordable rents, usually local housing allowance, and the rent payable to the private landlord will be indexed annually, usually with reference to CPI. The tenant, that is the affordable housing provider, will also, from those rents collected, need to accumulate appropriate funds to undertake maintenance over time and to pay for management costs. The lease will usually run for a long time, 20 years plus, actually more likely to be 25 years as a minimum. And at the end of the term, the tenant, affordable housing landlord, affordable housing provider, will hand the housing back to the private landlord unless there is an option to extend or a reversion. The long lease term of the 20 years plus is a positive for the affordable housing provider tenant in terms of the long lease, because that in and of itself creates an interest which is land registerable and creates a real right for the tenant, which I will speak a little bit about in one of the next slides. But really the purpose of this seminar today was to get into the differences between being a tenant compared to being an outright owner. And so I wanted to go through the kind of main points of what's involved in ownership and compare that with the position as a tenant in terms of an investment lease with an investor landlord. And the first and main point is obviously around possession. As an owner, an affordable housing provider will be entitled to possess without any interruption for an unlimited period of time. So they'll be able to own and occupy that property for as long as they want to own and occupy it, subject to obviously the interests of any occupiers occupying in terms of PRTs or SSTs, but there would be no, aside from any statutory inspections that were to be undertaken, there would be no third party with a right to come on to the property for any reason. In terms of the leasehold type arrangement, the affordable housing provider would be entitled to possess for the duration of the lease term. So for at least that 20 or 25 years or whatever the initial term of the lease is, without any interruption, except for the specific scenarios which are provided for in the lease, which would be where the landlord is permitted to take access, for example, to satisfy itself that the repairing obligation owed by the affordable housing provider to the landlord was being properly undertaken, or in the event of some kind of an emergency, the landlord in that scenario would be entitled to take entry to inspect or understand what that emergency was and how it had impacted on the property. But generally, those rights of access would be subject to protections for the affordable housing tenant and also for the underlying occupiers. I would expect that any right that's available to the landlord to access the property for any reason would be subject to the rights of the tenants in terms of PRTs and SSTs, and would also be subject, except for in the most limited kind of extreme emergency situation, to a prior notice period, prior notice to be served on the affordable housing provider before access is taken. The next one is around maintenance, and as an owner, responsibility for maintenance and repairs is your responsibility, subject to any responsibilities that tenants have in terms of PRTs and SSTs to maintain their individual homes forming part of the larger development. And the owner, as owner, you have the ability to program maintenance over the long term, and to manage a program of maintenance. In the leasehold scenario, it's not so different. There is, as I've said previously, as tenant in terms of that lease, the affordable housing provider will have responsibility for all maintenance and repairs, and will have the ability, insofar as you have certainty as to the overall length or term of the lease, to programme for maintenance over the long term. But the caveat to that is that any programming of maintenance would be subject to the repairing obligation in terms of the lease. And the repairing obligation will be in a kind of standard FRI type arrangement. The repairing obligation will be to maintain the property in good and tenantable repair. So the landlord would be entitled, theoretically, to claim that the property wasn't being maintained in line with that repairing obligation, where there was a programme of maintenance which allowed the repair to fall below that basic standard. But I think, given that in terms of duties as landlord, in terms of SSTs and PRTs, the affordable housing provider would be maintaining the property in line with the repairing standard. In any case, the risk of the base repair of the property falling below the repairing obligation in terms of the leases is relatively limited in the normal course of events. The next one is around dealings with the property, and by that I really mean the ability to dispose of the property, to walk away from it, and kind of cease having responsibility for that asset. As an owner, the affordable housing provider will be entitled to sell the property. It might be subject possibly to lender's consent, or it might be also subject to some consultation with the regulator in certain circumstances, and also subject to consideration of the interests of any occupiers at the time of the disposal, but by and large, the affordable housing provider will be entitled to dispose of the property either by selling it or by leasing it to a third party. In terms of the leasehold arrangement, again, the position is a bit different. By its nature, the lease will run for 25 years, and I would say that it would be unlikely and unusual for there to be a break option during that 25-year term. Generally speaking, from the investor landlord's perspective, they are looking for a fixed kind of income stream over a particular duration of time, or a minimum duration of time, which generally would be that 20 to 25-year period. And there wouldn't be a break, because that would introduce uncertainty as to that income stream. So in the absence of the ability to break from the lease, the affordable housing provider's option would be to assign its tenant's interest in the lease to another RSL. So that basically means to essentially transfer their tenant's interest in the lease to a third party, and for that third party to step into their shoes and become responsible for all of the obligations that are due to be performed to the landlord in terms of the lease. Generally speaking, assignation in that way will be permitted in terms of the lease, but it will be subject to landlord's consent. But that consent usually wouldn't be unreasonably withheld where the incoming tenant is an RSL and demonstrably able to meet the obligations due to be performed by the tenant in terms of the lease. And the reason for that is really to provide certainty to the landlord that the property will, or it's one of a couple of measures kind of inherent in the lease that are designed to make sure that the property continues as an affordable housing, as opposed to any other kind of housing, or market housing particularly. And that the investor landlord will often be interested in making sure that it is the case that the landlord will continue to be an RSL, because it's likely that the investment has been made in the first place in accordance with a mandate which has provided for the housing to be specifically affordable housing, and it might even be specifically envisaging that the landlord is a regulated provider, an RSL. And so for that reason, the landlord will want to restrict the disposal of the tenant's interest to other incoming tenants who meet that criteria. The next one I wanted to speak to was outgoings, and that was really to say this is an area where ownership and leasing are very similar. As owner, there will be responsibility for all the outgoings that are associated with the property, including payment of insurance, obviously any payment of any secured debt, but payments in terms of any title conditions, council tax rates, contributing to the maintenance of a shared fence. All of these kinds of things would be the responsibility of the owner. And likewise, in terms of the lease, the obligation to meet all those outgoings will be passed on to the tenant. So, and that includes any title obligations, notwithstanding that those theoretically rest with the owner of the property, those will be passed on to the tenant in terms of the lease. The big difference, obviously, is that in terms of the lease, as tenant, the affordable housing provider will have to pay rent in addition to all of the other outgoings. But that it's assumed that the payment of rent would be instead of any payment in respect of any secured lending against the property, and that it would be equal to or less than what that would be. So it's not, it shouldn't be the case that the rent is an additional sum, but it's a kind of alternative sum to what other finance costs might be against the property. The next one here is security of tenure, and this is just going back to the point around the real right that I mentioned earlier on. Basically, as an owner, you in the context of kind of land law and conveyancing, as an owner, you will have a real right to the property, which means it's your right in the property is better than anyone else's anyone else's right, or it will trump anyone else who comes forward and claims to have a right to occupy that property. So it's really the circumstances in which your occupation could be interrupted by a third party are very limited from that perspective. In terms of the leasehold arrangement, the tenant, as tenant, an affordable housing provider will also have a real right in the property, and that will be by virtue of the lease where it's over 20 years being registered in the land register. And that means that you will, an affordable housing provider would have a title sheet with its name on there as proprietor, but it would be proprietor of the leasehold interest. But the difference is that the landlord, there is the potential for the landlord to bring the lease to an end in the way that ownership can't be brought to an end by a third party usually. But that would be only in the limited circumstances where the tenant hasn't performed its obligations in terms of the lease, and it would be particularly in relation to the payment of rent. But usually the lease would incorporate standard protections for the tenant, particularly around notice, notification of breach, and a couple of different notice periods prior to the lease being terminated. But it's also quite common to see in lease arrangements like this that as an alternative to termination, the landlord could require or oblige the tenant in a breach situation to assign its interest to a third party RSL that's been selected by the landlord. So that would be, that the scenario would basically be kind of RSL A is in a breach of the lease for whatever reason. The landlord lines up RSL B to take on RSL A's interest in the lease and to continue the lease going forward. Obviously, that's the best outcome for tenant occupiers who would be able to stay in there without the landlord would change, but otherwise there would be no impact, and there would be no impact on tenure. But it also just goes back to that point that I made earlier on about the landlord is looking to have security that the asset will continue to be operated for affordable housing, specifically for that affordable housing purpose for the long term, whatever that term is fixed at the start. So it's not really, the point is it's not really in the landlord's interest to bring the lease to an end unless there's a real significant reason to do that, and not really any further option. The last point that I wanted to make that occurred to me after I'd finished making this slide, unfortunately, was as to around the use of the property. And generally speaking, in both the ownership and the tenancy position or scenarios rather, the use will be fixed in the planning context by, so sorry about that. I was going to mention the use of the property. So generally speaking, the use of the property, whether this is in an ownership or in a landlord and tenant situation or scenario, will be dictated by the the permitted use in terms of the planning permission, and it will be equally in the ownership and the landlord and tenant scenario. It will be up to the affordable housing provider to make sure that there is appropriate planning permission specifying the permitted use in place prior to the use commencing. The lease will usually include a permitted use clause in addition to that, which will restrict the use of the property to the use for affordable housing, and will specify probably reasonably tightly any ancillary uses, such as if the housing was for specialist care purposes, then if there was a warden's accommodation or a shared space, for example, then in that case, it's likely that the permitted use would be specific about that. And again, that's just going back to the point from the landlord's perspective, whereby the intention is to make sure that the asset is used for the affordable housing purpose that's specified at D1 all the way through the term. I think, Aisling, could you move on to the next slide now, please? Thanks. And Claire will now speak to the construction assurance piece. Thanks.
Thanks, Jenna. Hi, everyone. So I'm going to talk about how being a tenant of a new development compares to buying off the shelf or traditional procurement yourself of a design and build project, and really what protections you should be looking for from a construction point of view. If you're entering into a long lease of a new or a recently built property under an FRI lease, as described by Jenna, what protections should you be looking for in respect of the integrity of that built property? So I think in this scenario, it's helpful to consider firstly what a typical RSL would have the benefit of if it was procuring the works directly themselves. There's not really much difference between what you should expect where the RSL is itself building the property, or buying a property upon completion, or leasing under a long FRI lease, as Jenna's described, in terms of the protections and the rights of recourse you would expect around any defective works within the property. So if an RSL was procuring works themselves, then we would be recommending that they enter into a full suite of construction documentation. And by a full suite, what we mean is appointments of any site investigation consultants or any other consultants who are providing reports in relation to the site that the properties are to be built on. There would be a building contract with the main contractor, typically a design and build contract. There would be appointments with each member of the professional team. So that would be the design consultants like the architect and the engineer, and the other professional consultants like quantity surveyors, project managers, principal designers, employers agents, contract administrators, etc. You would also typically expect to get subcontractor collateral warranties from those key subcontractors who sit underneath the main contractor in your building contract. And this suite of documents would mean that the RSL who was procuring those works would have a contractual recourse in relation to the obligations of the parties during construction, but also for defects, including latent defects that would arise once the building has been completed. We would expect the building contract to be on an industry standard form, perhaps an SBCC form of contract. There might be some bespoke amendments to cater for the particular builds. So in this case, it could be the secured by design requirements or the Scottish Government's energy efficiency standard for social housing. And there might be additional deliverables that the contractor would provide, for example, a home warranty certificate like an NHBC cover or similar. We'd expect the professional team appointments to be in a bespoke form that all mirrored each other. This is really because the industry standard form of consultant appointments that are produced by the architects governing bodies or the engineer governing bodies don't tend to align with each other, and they include fewer obligations on the consultants and more exclusions and limits on liability. So in the scenario we're discussing today, the RSL will be responsible under the terms of its lease for repairs to the property. And if repairs have to be carried out as a result of defects in the construction of the building, it's important there's a full construction package there available to provide that RSL with contractual recourse for the cost of correcting those defects that fall to it under its repairing obligation under the lease. So the suite of construction documents I've just outlined would provide this for the RSL, where the RSL is procuring the works itself. But obviously in this scenario, the RSL is the tenant and is not a party to the original procurement of the works. So what we would want to do in that scenario is put in place some additional documents in the form of reliance letters and collateral warranties. These would be granted by the main building contractor, each of the professional consultants, and some of the key subcontractors. Now, these collateral warranties are what we call unilateral undertakings from the grantor of the warranty in favour of the RSL. The grantor of the warranty essentially warrants that it has complied with its obligations under either the build contract or the appointment or the subcontract, and that it has used reasonable skill and care in carrying out the design services and the construction of the works under those contracts. Now, what these collateral warranties do is they provide a direct contractual recourse for the RSL tenant against the contractor, subcontractor, or consultants who carried out the design and build of the works. And then the RSL would be able to sue those parties under the collateral warranty if a defect arose due to that party's default. Now, collateral warranties, as indicated by the name, are collateral to the underlying building contract, appointment, or subcontract. Therefore, the value in them and the potential scope
to get compensation under them really depends on what the underlying terms and conditions in the building contract, appointment or subcontract say. So if, as an RSL, you were being provided with a package of collateral warranties upon taking an FRI lease, what you would also want to do would be carry out a due diligence of the underlying construction package to ensure that they're in an institutionally acceptable form and they would provide the expected level of protection should you ever have to sue those parties under the collateral warranties. I did mention NHBC home warranty certificates. There's a variety of different providers, so it could be NHBC or another. If these home warranty certificates are being provided in respect of the properties, then the RSL under the FRI lease should make sure that they look to have the benefit of those warranties sit with them so that they can make a claim directly against the warranty provider in the event of any defects being discovered. So the question can arise, do you need all those collateral warranties that I just discussed if you also have an NHBC or equivalent cover? There is an argument if you have NHBC that might be sufficient, but it's worth noting that NHBC will only cover certain defects which are listed out in the warranty cover, whereas a collateral warranty, say from a building contractor, would cover anything that arose as a result of the breach of obligations of the contractor under the main contract. So it might actually provide greater compensation to the RSL. Depending on the nature of the defect, however, it might be easier to claim against the NHBC warranty. So as a starting point, we would always advise the RSL in this situation to get the benefit of both the home warranty cover, be that NHBC or other, and collateral warranties. So that covers what protection the RSL should look for once it enters into the lease. However, skipping back one stage, there are some construction-related provisions and rights that the RSL should be looking to have covered in the agreement for lease before it actually enters into the lease. So, for example, the agreement for lease might set out the specification that the property was going to be constructed to, and the RSL will have approved that in advance, and they would want to make sure that the party that was procuring the works didn't make any changes to that before the lease had commenced. If the lease would typically be, the date of entry under the lease would typically occur on what we call the date of practical completion of the works. So we would expect that the RSL would have rights to inspect the works prior to practical completion being certified. As I've said, practical completion will trigger the date of entry under the lease, so it's an important milestone that indicates the properties are in a particular state of readiness to be occupied. So whoever's administering the build contract should be bound to take into account any representations made by the RSL at that stage, and there might even be a right to refer to a third-party expert if there's any disputes on whether or not practical completion has been achieved, given it is such a significant part of the process. And finally, under the agreement for lease, there'll probably be some provisions around snagging and defects in the first year of the property for new builds. At practical completion, there might be some minor snagging items that need to be completed, and the RSL would want them to be rectified as quickly as possible so that they don't fall into their repairing obligation under the lease. So there should be an obligation on the landlord to ensure that those are rectified as soon as possible. Similarly, under a typical building contract, there'll be a 12 or sometimes a 24-month defect liability period. And during that period, it should be the landlord that's under an obligation to procure that any defects identified in that period are rectified by the contractor rather than the RSL under the FRI lease. In relation to defect rectification, there'll probably be a protocol around the timescales for those defects to be corrected. So, for example, emergency, urgent, or non-urgent categories of defects might have different timescales within which those defects are to be rectified by the landlord. And there should also be a protocol in place about how rectification of those defects interplays with the RSL's tenants who are in occupation of the various units. So these are all things that should be checked as part of the RSL's diligence on the construction package. And that's why it's important to take that into consideration when you are thinking about taking on an FRI lease of a new build property of this type. Thank you. Thanks very much for that, Claire. The last bit I wanted to speak to was really around tenure suitability and whether or not a lease can deliver housing for Scottish secure tenancies, short secure tenancies and private residential tenancies, and really, is it kind of legal and does it work from a legal perspective? And there really are two parts to the answer to that question. The first is more of a conveyancing type issue as to whether or not it is actually legal to grant or to enter into long leases of housing specifically, not in terms of a PRT or an SST or an SSST, and whether or not there are any prohibitions in the Housing Acts and relevant legislation that would prohibit housing being leased in terms of PRTs or SSTs where the landlord's interest is not actually an ownership interest. So on the first point, generally speaking, it is not legal to enter into long leases of housing. That was previously quite a wide practice, but it was abolished as part of the feudal reform, abolition of feudal tenure in terms of the Land Tenure Reform Scotland Act 1979. But that general prohibition of long leasing of housing, there is an exception to that general rule for social landlords, local authorities and their controlled subsidiaries. So that means that an RSL can enter into a long lease of housing, and it also means that an RSL could enter into a long lease of housing and then itself grant a lease of that housing to, for instance, its mid-market rent SPV, for that SPV to operate the housing for mid-market rent. In terms of the position in terms of the Housing Acts, there is no prohibition in any of the Housing Acts to housing being leased in terms of SSTs or SSSTs where the landlord's interest is not an ownership interest. And the Schedule 2 of the Housing Scotland Act 2001, when it sets out the grounds for the recovery of vacant possession of housing, does specifically provide that a court might order recovery of possession where the landlord's interest is a tenant's interest under a lease and the lease has been terminated, or it will be terminated within a period of 6 months from the date of raising proceedings. So it was envisaged when that legislation was put in place that RSLs might well grant SSTs where they don't own the property in question. Could we move on to the next slide, please? When it comes to mid-market rent housing and private residential tenancies, I've referred specifically to PRTs on the basis that PRTs are the prevailing tenure in mid-market rent housing. There's no, again, there's no prohibition in terms of the Private Housing Tenancy Scotland Act 2016 to PRTs being granted by a landlord who themselves is not the who's not the owner of the property, and it's quite common for RSLs to lease housing to their MMR SPVs, as I say, specifically for the purpose of operating mid-market rent housing, using the PRT tenure rather than SST, which would be the case if the lease was granted by the RSL proper. Also in the BTR type scenario, it's quite common in our experience for BTR assets to be subject to a kind of property company, operational company structure, whereby the property company would lease to the operating company, and it would be the operating company that would grant the PRTs of the individual dwellings. Section 46 of the Private Housing Tenancy Scotland Act does include some subtenant protections as well, in providing that in certain circumstances a tenant occupier would be entitled to be granted a new lease by the ultimate owner in the event that any mid-lease was terminated. But that was all really I had to say on this topic. Ashley, we could just move on. I think the point really that we're trying to make here is that it's generally recognised that to meet affordable housing needs, some innovative approaches are required, and that is in of itself acknowledged by Housing to 2040. We know that private investors are keen to invest in affordable housing in Scotland, and within the current legislative framework, it is possible for affordable housing providers to take advantage of the interest of private investors to deliver affordable housing in Scotland by way of a lease model, provided that the terms are carefully drafted to protect the interests of the RSL and their tenants and their overriding interest in delivering affordable housing, and to protect the construction liability position, as Claire discussed.
Thanks very much, Jenna. And Claire, that was really, really good. We do have a question, but I have one question first. Can you give us any existing examples of private sector investment in affordable housing?
I can, yeah. We have recently acted for an investor landlord who has leased a small development to an RSL. But aside from that, there are there are examples of public-private initiatives that have brought forward the delivery, particularly of mid-market rent housing. The National Housing Trust is a good example of that was led by SFT and basically involved private sector, basically involved partnerships between private sector and public sector partners owning and operating mid-market rent housing, and the acquisition of the housing having been funded with a mixture of public and private funding. So that that was limited to the mid-market rent context, but it was a really good example of public and private partnerships delivering affordable housing.
Excellent. And another question that we've got, and then we will need to wrap up. So if there's any further questions, please don't hesitate to contact either Jenna, Claire, or myself offline. But one of the questions that we've got here is that in relation to the agreement that are put in place with the tenants, when would it be more appropriate to offer a short Scottish secure tenancy as opposed to a Scottish secure tenancy? And then they're talking further, is a short Scottish secure tenancy still appropriate if it's being offered as temporary accommodation for anticipated medium term, for example, years? Do you want me to take that one, Jenna?
I'm happy for you to do that, Fiona. Yep.
In terms of a short Scottish secure tenancy, yes, by their very nature, they're meant to be temporary tenancies, or alternatively, they're effectively demoted tenancies as a result of antisocial behaviour, and that's only for a period of time of 18 months. A short Scottish secure tenancy can be in place for a longer term, so it could be for the medium term, but generally that's only when there's support services that are put in place to support the tenant ultimately move on to a full Scottish secure tenancy. So generally, from what Jenna was talking about earlier, we would be looking at the Scottish secure tenancies for tenants rather than the short Scottish secure tenancies in this particular instance. Unless you have anything else to add to that, Jenna, we'll just wrap up there and say thank you very, very much for joining us this afternoon. We do have other sessions coming up. So please make sure that you have a look on our social housing page on our website for those sessions that are coming up in the future in our social housing webinar series. As I mentioned, our contact details are on the slides. Thank you very much for attending and enjoy the rest of your afternoon.